Prince Harry lost every claim he advanced in the Daily Mail case, but within hours that legal defeat was being used to predict something the judge never ordered: punishment through his family's royal titles. 7 claimants failed to prove that Associated Newspapers had used unlawful methods to obtain the information behind the articles and incidents before the High Court. Yet the story quickly expanded beyond the evidence. Harry was called a proven liar. Commentators said the press could now say almost anything about him. Meghan and the children were pulled into a discussion about losing status. The central question is no longer whether Harry lost. He did. The question is where the judgment ended and where the punishment campaign began in the public narrative. The case involved Prince Harry, Baroness Lawrence, Sir Elton John, David Furnish, Elizabeth Hurley, Sir Simon Hughes, and Sadie Frost Law. They accused Associated Newspapers, publisher of the Daily Mail, the Mail on Sunday, and Mail Online, of unlawful information gathering. The allegations included phone interception, deception to obtain private data, and unlawful investigator activity. The trial lasted 46 days. The judgment ran to hundreds of pages. The claimants failed across the case because the court was not persuaded that the specific information in the disputed articles had been obtained through the unlawful methods alleged. A story can contain private, upsetting, or unusually accurate information without proving how that information was acquired. The court repeatedly returned to the same principle. Suspicion, even understandable suspicion, is not proof. The claimants had to show on the balance of probabilities that Associated was legally responsible for unlawful information gathering connected to each article or incident. It was not enough to point to private details and ask how else a journalist could have known them. It was not enough to show that private investigators had worked within the tabloid world. The evidence had to connect an alleged unlawful act to the particular material being challenged. The decisive weakness was not that Harry wrote a memoir, disliked the press, or appeared angry outside court. It was the gap between private information and article-specific proof of unlawful sourcing. In some instances, the court accepted evidence that journalists had confidential human sources. In others, contemporaneous documents supported ordinary reporting routes. Some allegations depended on inference upon inference. Some changed in emphasis by the time of trial. The judge did not say that tabloid journalism had always been admirable. He said these claimants had not proved these particular allegations against this publisher. The opponent transcript says Harry's reputation has been trashed and that he has been shown to be a liar. But the judgment did not make a finding that Prince Harry gave untruthful evidence. Associated Newspapers itself did not advance a case that Harry had lied under oath. His claims were dismissed because the alleged unlawful sourcing was not proved. A failed claim can damage credibility, especially when it was pursued publicly and at enormous cost. But an evidentiary defeat is not automatically a judicial finding of dishonesty. It is the difference between saying you have not proved your allegation and saying you deliberately invented it. Those are not the same verdict. A claimant can genuinely believe that private information was obtained unlawfully and still fail to establish the required evidential link. The judgment acknowledged that some of Harry's concerns were genuinely held. It also found that, in the articles examined, suspicion did not overcome lawful explanations or the absence of direct linkage. That leaves Harry with a major loss, but not the character judgment his critics immediately attached to it. The number being repeated after the ruling creates another problem. Commentators say 97 out of 97 were rejected, often in a way that makes it sound as though Harry personally told 97 lies. The court's own summary says it considered 57 separate articles and incidents. The figure of 97 came from the winning publisher's statement and referred to allegations across all 7 claimants. Both figures can describe different parts of the case, but they are not interchangeable. Most importantly, neither figure represents 97 separate lies told by Prince Harry. The court's number describes the articles and incidents examined. The publisher's number describes the allegations it says were dismissed. The commentary then personalizes that larger number and attaches it to Harry alone. By the time the figure reaches the audience, 7 claimants have almost disappeared. 97 allegations become 97 Harry failures, and 97 failures become proof that his entire public campaign against the press was fraudulent. The number grows more emotionally powerful as its context becomes smaller. He chose to bring serious allegations. He gave evidence. He attached his name and reputation to the case. The publisher was required to defend itself through a long and expensive trial. When a claimant accuses journalists and executives of unlawful conduct, the burden cannot be softened because the claimant is famous or because the subject is emotionally charged. If the evidence does not prove the allegation, dismissal is the correct result. Royal Receipts is not here to rescue Harry from the consequences of the record, but the record also does not justify turning one loss into a ruling on every dispute Harry has ever had with the media. His broader litigation history is mixed. He has previously obtained findings or settlements in other cases involving other publishers and different evidence. That does not help him win this case. Each defendant, article, and sourcing allegation stands on its own. But it does mean the sentence, Harry's entire campaign was exposed as false, is broader than the legal record can support. One case can be a major defeat without becoming a judicial eraser over every earlier case. The court was also not conducting a public inquiry into every practice used by the British press over several decades. It did not decide that unlawful information gathering had never happened anywhere. It did not give newspapers permanent immunity from privacy law. It examined pleaded claims linked to particular articles and incidents. The claimants had to prove those claims against associated newspapers. They failed. That result may strengthen the publisher's public position, but it does not mean the press can now publish anything it wishes about Harry without legal limits. The opponent transcript goes much further. It suggests Harry has opened the door for the press to say whatever it wants because he wrote spare and has spoken about his private life. That argument confuses voluntary disclosure with the total loss of privacy. A public figure can reveal parts of his life and still retain legal rights over other information. Writing a memoir may affect expectations and arguments in a specific dispute, but it does not create unlimited permission for surveillance, hacking, deception, or false reporting. The court did not grant such permission. It found that unlawful sourcing had not been proved in the claims before it. The next dramatic claim concerns money. The opponent speaks of a £50 million bill as though Prince Harry has already been handed a personal invoice for the entire amount. That is not what the judgment established. The figure being reported relates to the scale of Associated Newspapers' legal costs and the amount the publisher says it will seek. Consequential orders, including disputed questions following the judgment, were scheduled for a later hearing. The final liability of each claimant cannot simply be read from a headline or divided by 7. Even when insurance or litigation arrangements cover part of an exposure, losing a case of this scale can produce severe financial consequences. It can also make future litigation harder to fund and increase pressure on the claimants to appeal, settle related matters, or step back. But a reported total cost figure is not the same as a final personal debt. The receipt must distinguish the amount claimed by the winning side, the amount eventually ordered, and the share allocated to any individual claimant. The appeal discussion has been similarly personalized. The opponent suggests that Harry may appeal because his lawyer does not like losing, and because Elton John is determined to continue the fight. Those are character stories, not legal tests. An appeal would require permission. The legal team would need arguable grounds showing that the decision was wrong or unjust because of a serious procedural or other irregularity. Disagreement with the judge's assessment of witnesses is not enough by itself. Anger is not a ground of appeal. A lawyer's reputation for persistence is not a ground of appeal. That does not mean an appeal is impossible. A judgment of this length may contain points the claimants believe should be reviewed. They may challenge a legal approach, an evidential ruling, or another part of the decision. But until formal grounds are identified, the responsible description is that appeal options may be considered. It is too early to say the claimants will succeed. It is equally careless to say no appeal could ever be permitted simply because the trial judge was experienced. The receipt is the filed appeal notice and its grounds, not speculation about personalities. Then the story makes its largest leap. The court loss becomes a discussion about Harry, Meghan, and their children losing royal titles. Nothing in the judgment altered Harry's dukedom, his status as a prince, his place in the line of succession, or his position as a non-working member of the royal family. Those are separate constitutional and institutional questions. The High Court was deciding whether unlawful information gathering had been proved. It was not deciding who may be called a prince, who holds a peerage, or who remains in the succession. The word title makes the proposed punishment sound simple, but it hides several different statuses. The Duke of Sussex is a peerage. Prince is a royal title connected to Harry's birth. His HRH style has a separate practical and constitutional history. His place in the succession is governed by law. His former role as a working royal concerns duties, funding, representation, and institutional access. Changing one does not automatically change the others. A civil privacy defeat does not contain a hidden constitutional switch that removes them all. Some royal styles and honors can be altered through action by the monarch under particular legal and constitutional arrangements. A peerage raises a different set of questions. Removing someone from the line of succession requires legislation, and changes touching succession involve wider constitutional considerations across the realms that share the crown. The precise process depends on what status is actually being discussed. That is why saying Charles should take the titles tomorrow may work as a comment war line, but it does not describe a single clear legal process. The court judgment created no automatic title penalty. No paragraph orders Buckingham Palace to begin a review. No finding says Harry's wife or children should lose status. No part of the ruling converts failure to prove unlawful sourcing into disqualification from the monarchy. King Charles may face political, family, or reputational pressure over Harry. Commentators may argue that non-working royals should not retain titles. Parliament may debate reform. But those are separate discussions. They must not be presented as a consequence already contained in the judgment. This is where the family punishment expands beyond the claimant. Harry brought claims as one of 7 adults. Meghan was not one of the 7 claimants in this action. Archie and Lilibet were not claimants. Yet within the opponent's discussion, the consequences quickly spread to the wife and children. Their status becomes part of the proposed answer to Harry's failed evidence. A legal defeat belonging to a husband is transformed into a debate about what should be taken from the woman beside him and the children behind them. For many women watching in Britain and the United States, that pattern is recognizable even without the royal setting. A husband makes a public decision, takes a legal risk, or loses a professional fight, and the wife is treated as part of the wrongdoing whether or not the record connects her to it. She may be blamed for encouraging him, controlling him, or benefiting from him. If the marriage is already unpopular, the evidence standard becomes even weaker. The woman's presence is made to look like participation. That does not make Meghan immune from scrutiny. She and Harry have built commercial projects around their identities and their royal connection. Their choices can be examined. Their public statements can be checked. But this particular judgment did not decide a claim brought by Meghan. It did not find that she planned the litigation, directed the witnesses, or caused the evidential failures. Pulling her into the punishment may satisfy an existing opinion of the Sussexes, but it does not come from the court record. The children require even greater discipline. Adult arguments about monarchy, privilege, and succession can legitimately include questions about how titles should work in a modern institution. But children should not be used as leverage in a reputation war between adults. If their status is ever changed, the legal and constitutional reason should be stated honestly. It should not be framed as though a judge imposed a family penalty because their father lost a privacy case. The judgment did no such thing. The same discipline is needed when commentators compare Harry with Andrew. Both men have caused serious reputational problems for the monarchy, but the legal histories are different. Combining them may create a powerful theme about royal entitlement, but it can also smuggle allegations from one person's record into another person's story. This case concerned claims against a newspaper publisher. It was not a trial of Harry's military service, marriage, drug history, charitable work, or suitability for royal life. Those subjects may create cliques, but they do not explain why these claims failed. The opponent transcript repeatedly leaves the judgment to discuss Andrew's travel, the York daughters, royal accommodation, Buckingham Palace, the Gulf, royal finances, religion, and the future of the monarchy. That structure keeps producing fresh conflict, but it prevents the audience from seeing the most valuable receipt clearly. The stronger royal receipts version stays with the legal chain. What was alleged, what had to be proved, why the proof failed, how the numbers were framed, what an appeal would require, and why title removal is a separate process. The reputation stakes remain high even without exaggeration. Harry has spent years presenting his legal campaign against sections of the British press as a matter of principle. Losing this case weakens his ability to control that story. It gives his critics a powerful receipt. It allows associated newspapers to say its journalists were vindicated in this action. It may affect public confidence in Harry's judgment and in the people who advise the claimants. It may also expose him to significant costs. None of that needs to be inflated, but reputation moves in both directions. The publisher controls the first victory statement. Commentators choose the strongest number. Headlines convert dismissal into humiliation. Guests move from a failed evidentiary case to claims about character and family status. Once that chain is complete, the audience may remember 97 lies, even though the court did not use that phrase about Harry. The formal judgment remains available, but the emotional summary becomes the public record most people carry. That is the story control mechanism at the center of this video. The judge controls the legal decision. The winning party controls the first triumphant interpretation. Commentators control the moral expansion. Social media controls the shortest version. Harry controls only his response, and an angry response can make the losing side look less credible, even when it raises a legitimate distinction. By the time the story reaches the public, the legal question has been replaced by a character question. What kind of man loses this badly? Harry's criticism of the ruling may deepen that reputational wound. A losing claimant who attacks a judgment risks appearing unwilling to accept evidence that went against him. But criticism does not erase the need to describe the ruling accurately. The audience can believe Harry exercised poor judgment, pursued claims he could not prove, and responded badly, while still rejecting the claim that the court branded him a liar or ordered consequences for Meghan and the children. Those positions are not contradictory. The strongest case against Harry is clear. He joined a case built on serious allegations. The claimants had years to prepare. They proceeded through a long trial. They failed to connect the alleged unlawful methods to the articles and the incidents on the required standard. Associated newspapers successfully defended the action. Harry now faces reputational and potentially substantial financial consequences. His public campaign against the press has suffered a severe setback. No responsible analysis should hide those facts. The strongest counter case is narrower. Harry may have held genuine suspicions about how private details entered the press. Some of the information was intrusive. Historical wrongdoing elsewhere in the newspaper industry made those suspicions understandable. But suspicion and industry history could not replace article-specific proof against this defendant. The counter case does not reverse the result. It explains why the failure to prove the claims is not identical to proof that Harry fabricated every concern or lied about his experience. The strongest case for a future title debate is also separate from the court. Critics may argue that people who do not perform royal duties should not commercially benefit from royal styles. They may want a smaller monarchy. They may believe Harry's repeated attacks on institutions make continued titles inappropriate. Those are political and constitutional arguments. They can be debated openly, but attaching them directly to this judgment creates a false bridge between civil evidence and royal status. The strongest case against that bridge is simple. The judge had no title question to decide. The court did not hear constitutional arguments about the dukedom, princely status, or succession. Meghan and the children were not placed before the court for punishment. The ruling dismissed claims against a publisher. Any later decision about titles would need its own authority, process, and justification. It would be a new event, not an automatic effect of the old one. What then is proven? 7 claimants, including Prince Harry, failed to prove their claims of unlawful information gathering against associated newspapers in the articles and incidents examined. The court dismissed the claims after a lengthy trial. Harry suffered a major legal and reputational defeat. What is credibly reported? Associated Newspapers has described the result as an overwhelming victory and has referred to 97 dismissed allegations. Large legal costs have been reported, and further consequential orders were scheduled to be addressed separately. Appeal options may be considered, but the success of any appeal would depend on formal grounds and permission. What is disputed? The broader meaning of the judgment is disputed. Harry and his supporters may view the ruling as a failure to recognize hidden or historic misconduct. The publisher says its journalism was vindicated. Critics say Harry's campaign has collapsed. The judgment itself resolves the pleaded claims, not every moral argument about press conduct. What remains unknown? The final cost position for each claimant, the precise grounds of any appeal, whether permission will be sought or granted, and whether the political debate about Sussex titles will lead to any official action. None of those questions was settled by the judgment handed down in this case. And what did the public commentary exaggerate? The court did not find that Harry told 97 lies. It did not rule that every complaint he has ever made against the press was false. It did not give newspapers unlimited freedom to invade his privacy. It did not remove his dukedom, princely status, or place in the succession. It did not order the punishment of Meghan, Archie, or Lilibet. The final verdict is therefore uncomfortable for both extremes. Harry cannot call this anything other than a serious defeat. The evidence he and the other claimants presented did not earn the conclusion they asked the court to reach. But his critics cannot honestly place words in the judgment that are not there. The legal verdict was that the unlawful sourcing alleged in this action was not proved. The character verdict and the title verdict were added afterward. That distinction is the receipt. A court loss can reveal poor judgment without proving every insult. A victory statement can use an accurate number while commentary strips away its context. A constitutional debate can be legitimate without pretending a civil judge already decided it. And a husband's legal defeat can be serious without becoming evidence against his wife and children. Prince Harry lost the case. What he did not lose in that courtroom was his title, his place in the succession, or the legal status of his family. Those consequences may be demanded by commentators, debated by politicians, or considered by the palace in the future. But they were not ordered by the judge. So when a court delivers an evidence verdict, who has the right to turn it into a family sentence?